In the realm of law enforcement, the actions of police officers are scrutinized closely, and when a chief of police finds themselves at the center of controversy, the consequences can be severe. In a recent incident, the chief of police faced termination following a particular traffic stop that raised eyebrows and raised questions about professional conduct. Join us as we delve into the details of the encounter that led to the chief's dismissal and explore the broader implications of such incidents on the relationship between law enforcement and the communities they serve. On June 3, 2022, Police Chief Anthony Alves, who was off duty and dressed in plain clothes, was driving an unmarked vehicle in Elmira, New York. During his commute, he observed a dispute involving 30-year-old Isaiah Bowman Thomas and another individual, sensing the potential for a physical altercation. Chief Alves pulled alongside of them, inquired about the situation, and allegedly faced a challenge to engage in a fight from Mr. Bowman Thomas. Responding to continued aggressive movements by Mr. Bowman Thomas, Chief Alves, at gunpoint, ordered him to drop the open knife he was holding. Following compliance, Chief Alves instructed him to lie on the ground. It's noteworthy that Chief Alves did not have a body camera, thus the initial confrontation with Mr. Bowman Thomas was not recorded. Subsequently, backup officers arrived, and their interactions with Mr. Bowman Thomas, including his arrest, were documented using their body cameras.
You want to treat the black people like this. Watch this.
All right, we're rolling on your side.
Watch how you guys
got a couple more knives.
Yeah, I got one more knife.
Where is it?
I just showed you right here.
All right.
In my pocket. You don't feel that? It's all on camera. I will have your job. Now what are y'all doing?
Just slide in.
I don't have no warrants. So what am I being
Slide
detained
in.
for? What am I being detained for?
Threatened me with a knife. I don't know what else more to tell you. He was fighting with a guy on the other side of the street, challenged each other. I pulled up and said, "You guys done?" He asked me if I wanted to fight. I said, "I want you to move along." I come around. Come on.
What am I being arrested for?
Well, that will be discussed shortly.
You said you saw the whole thing? When you came at me with a knife? When did you start recording?
When you pulled your gun
Did
on
I pull
him?
my gun out on him?
Yep.
Good, because they still have the knife in his hand, so
Well,
I'm going to need their information.
I didn't record
Can we
nothing.
check
up
that,
until-
please? Make sure
No.
you don't record this evidential effects, because I don't have a camera on my car and I don't have a body cam,
Well, you should.
but it's evidence. So if you
No.
caught him with a knife in his hand,
I did not.
that would help me with
I
my
did
criminal
not.
case.
I just said I did not.
Can we check?
Then what's the point of this?
No.
Then why are you
If you
filming
didn't have it? If the whole point is
What
to
if-
get evidence for a
what-
criminal matter.
What if I was doing it for the benefit of you and now y'all are coming at me with
I am.
No, no.
I know. Can I have the video for the benefit
No,
of
you
it?
cannot because it's.
So
this
you're
is-
not doing it for the benefit
This
of
is
the
not my phone.
It doesn't matter.
You're in
in
possession
control
It
of it.
does.
No, it doesn't.
That's
man.
not my car, but I'm in control of it. It's the city of Elmira's car.
Good. Can I have it?
No.
There's no reason for you
Good
to have
point.
it.
Touche.
Chief Alba requested the witness to allow him to review the video footage on her phone pertaining to the altercation with Mr. Bowman Thomas. However, she declined, emphasizing a well-established principle discussed numerous times here on ATA. Citizens generally hold no obligation to assist officers in their investigations. In the absence of exigent circumstances, officers typically cannot seize evidence or access data or video footage on an individual's cell phone without their consent. Nevertheless, officers and prosecutors possess procedural tools, such as warrants and subpoenas, to secure testimony and obtain evidence from witnesses. According to Section 6905 of the New York Criminal Procedure Law, a local criminal court may issue a search warrant upon the application of a police officer, district attorney, or another public servant acting in the course of their official duties. This statute defines a search warrant as a court order directing a police officer to conduct a search for the purpose of seizing designated property. Moreover, Section 69010 states that personal property can be subject to seizure if there is reasonable cause to believe it constitutes evidence related to an offense. Under Section 61010 of the same law, a person may be required to attend a criminal court action or proceeding as a witness through the issuance of a subpoena. The term subpoena also includes a subpoena ducis tecum, which directs the witness to bring specified physical evidence. If a witness is uncooperative, a material witness order may be obtained, fixing bail to ensure future attendance. While the witness was not obligated to grant Chief Alber access to her video recording, legal avenues such as search warrants or subpoenas could potentially facilitate the retrieval of the footage, and her appearance in court might be compelled through a subpoena or material witness order.
Anyway, so we're going to get your name because you're witnesses to this. I have
That's
to for
all
my
right.
UPR.
No, you don't.
I mean, my,
No, you do not.
not UPR, my use of
No, you
force
do not.
report. Yes, I do.
So you're just out here just to be jerks and
Can you
harass
please
us,
get
right?
the names?
Yeah, like seriously. Like, this is ridiculous. We didn't do anything wrong or illegal, yet you guys are not even remotely
Yo, neither
cooperating
did
with us.
I.
But
In the state.
I did not do anything.
no, but you're not cooperating in a criminal investigation. That's ridiculous. It'd be one thing if you just walked by.
All
and you-
I did
But you're
was
blatantly
see-
here.
All I did was see something
What did you
that
see?
happened.
Oh, something. So then what's the
I
point
see-
of, so just nothing. You just saw nothing.
Yo, yeah, get out of here.
Miss?
This is this
Hey,
is
stop.
whoa.
Stop. Don't approach her.
Get
that
out of
way.
my car.
We're not in your car. Back off or you're going to jail. We're not getting your car.
You're not going to tell me to get away from my car.
Please back away from us.
Right. There's no reason to approach
Please
the chief
back away
like
from
that.
my
I have every
car.
right to look at cars. It's called VNT.
Oh, I'm going to go look at your car then, all right?
You're not identifying yourself, so I'm going to use your vehicle.
You're not
as a-
identifying
as a
yourself
potential-
either. Neither one of you have identified.
Alvarez, 4588.
Okay, cool.
So I am going to identify you. You are a potential witness
Okay.
in a criminal matter, and
Okay.
now apparently you want to say that the police are abusing their power.
Whoa. Get out of here, man.
We don't need that.
You don't want
You
that
don't-
bad?
I
It's
just need
not
your name.
this. It's not.
You are going to give us, if this is your vehicle.
I have no problem giving you my name. That's not what
then
you all
do so.
started. That's not what
If
you
you don't
even
want to
started.
give us the video, we will subpoena it if we need to later. That
Go
is fine.
ahead.
And if you destroy it, it's evidence and it's a felony. So you cannot delete the video. Is that reading
It's
recorded?
not. It's
Yes.
not. It's not.
If you delete the video, you are destroying evidence, which is a felony in New York State.
Chief Alves cautioned the witness against deleting the video on her cell phone, asserting that such an action could constitute a felony offense. According to Section 21540 of the New York Penal Law, tampering with physical evidence is a Class E felony. This offense occurs when an individual, believing that specific physical evidence is about to be produced or used in an official proceeding, intentionally suppresses it through concealment, alteration, destruction, or by employing force, intimidation, or deception against any person. Section 25 and 35 of the Penal Law provides a broader understanding of physical evidence, encompassing articles, objects, documents, records, or other tangible items intended for use in an official proceeding. An official proceeding, in turn, refers to any action or proceeding conducted by a legally constituted judicial, legislative, administrative, or other governmental agency or official where evidence may properly be received. The 1979 case of People v. Nicholas established that the initiation of an official proceeding at the time of the act of concealment, alteration, or destruction is not a prerequisite for an act to be considered tampering with physical evidence. Subsequently, in the 1989 case of People v. Seaman, it was clarified that the phrase official proceeding is not restricted to those proceedings pending at the moment of tampering. The crime extends to both existing and prospective official proceedings.
You filmed me taking my gun out.
No,
and
I did
pointing it
not.
at him.
I did not.
You've already
film
admitted it.
that.
You said you
I
did.
I
You've already
said
did
I've
it.
seen it with my eyes.
We'll
I
just put
didn't record it.
And don't wave your
I
fist
didn't-
at me again.
I didn't.
You wave your fist at me again, I'm going to arrest you.
I didn't wave my fist at you.
Well,
Watch
that's
freaking. Yeah, I said this.
That's two.
Oh my God, get a grip,
Give
bro.
me your driver's license and your registration
No,
because
I
you
am
drove this
not.
car.
No, I.
You ain't. You're giving it to me because
Whoa,
you have to.
Whoa.
You don't have a
Whoa.
choice but to
What did
identify
I?
yourself.
What
You
did
have
I
to
do?
identify yourself.
What did I do?
You drove a car. Let me see your driver's license
What
to
did-
make
what-
sure that
what-
you are a registered driver.
Okay.
You inserted yourself into the situation, man.
No.
We
no.
did nothing to you.
No.
That's fine.
We had nothing to do with you until you inserted yourself and started filming. So now, guess what?
Listen,
inserted
you need to
yourself
lose
into
the
a
attitude because I was going to start being cooperative with you until you tell me to give me my
license,
give me my-
registration, insurance card, please.
No.
Yes.
You're out of your mind. I will
Then you will
gladly,
be under arrest for
listen,
obstruction.
I will gladly give you my license. I have to get in the car to
Okay.
get it.
Then
Where
go
is
ahead
it?
and do that, please.
In
I'm
my-
not retrieving it, but just
It's in my bag.
that black one right there?
No, the one back there.
Chief Alberis contends that the witness must present her driver's license, arguing that failure to do so could lead to her arrest for obstruction under Section 507 of the New York Vehicle and Traffic Law. This section stipulates that the failure to exhibit a license to a police officer shall be presumptive evidence that the individual is not duly licensed. While some states treat the refusal to display a driver's license as a separate offense, New York law, as clarified by the U.S. District Court for the Eastern District of New York in the 2019 case of Morrison versus City of New York, does not criminalize the act of failing to produce a license upon demand. Even if New York law did criminalize such refusal, it is well established that officers must have at least reasonable suspicion to request the display of a driver's license. Section 140(50) of the New York Criminal Procedure Law specifies that a police officer may stop a person when reasonably suspecting that they are committing, have committed, or are about to commit a felony or misdemeanor. However, this statute not only requires reasonable suspicion, but also does not authorize officers to demand driver's licenses or arrest individuals who refuse to identify themselves. Regarding potential charges of obstruction, Section 195.05 of the New York Penal Law outlines that obstructing governmental administration occurs when an individual intentionally obstructs, impairs, or perverts the administration of law or other governmental function. This can involve physical force, intimidation, interference, or independently unlawful acts. Courts consistently rule that a person's refusal to identify themselves, even when detained with reasonable suspicion, does not constitute obstruction. Several cases, such as Williams v. City of Mount Vernon, 2006, and People v. Gual, 2005, have emphasized that the failure to cooperate in providing identification cannot be the basis for an arrest without additional circumstances constituting probable cause. While providing contact information might influence the situation, the requirement of physical force, interference, or an independently unlawful act for an obstruction conviction makes it highly improbable for the witness to be found guilty of obstruction simply for refusing to show her driver's license to Chief Alvarez.
Oh, Jesus. You know that's a gift.
This?
That's a gift for my boyfriend.
We'll give it back. It's just we're holding it for safety right now.
That's fine with me. Okay, I can't get it.
She should not be reaching into the car.
She gave her permission to.
We ain't doing nothing like y'all are thinking, so just
For some reason, you want
cooperating at the moment, right?
Yeah.
Sure.
The sooner we get your ID, the sooner we leave.
I'm working on
Okay.
it. I just got my bag up here. There you are, sir, ma'am, sirs. Sorry,
Okay.
that's a joke that I do. That's bad joke timing.
Where do you live in these days? Still.
Right there.
Since you guys were so interested in this, I'll give you a rundown of what was going on.
You didn't talk to Comm Center about this?
Not her yet.
Additional subject for the Chief's blotter.
So, that is it. That's the extent of this. And I'm just curious why you wouldn't want to share that video to prove my case against somebody that was trying to get in fights with
It wasn't that I
Just
didn't want
add
to share it. It was that you wanted to take my phone.
You said you didn't have a certain part. I wanted
Right, I
to
didn't
watch
have-
the video to see what you had. But you didn't see him pacing back and forth and challenging me.
I saw it.
But not recorded.
No, excuse me. I did not see that part of it. I commend y'all for the jobs that you do. But you also have to understand that there are grimy ones with y'all too.
Right,
I
but
was
if we
starting
were
to be-
if we were one of those grimy ones,
Which,
even though yes, we were talking, going back and forth with you, but what would stop us from just like blatantly doing something savage to get that phone? We wouldn't. If the
Oh,
chief
not
was
enough
one of those
money.
grimy ones, as you said, I'm using your term. If he was one of those grimy ones, just pointing guns at people, just out hurting people, I highly doubt he would just let you sit there and record. You know what I mean?
I mean, you don't
Cr-
know that though.
Well, I guess what I'm saying is police that are out committing violent felonies, the showing of a camera wouldn't stop it. It wouldn't stop a
No,
civilian like that.
Right, but I'm not. You're going from one extreme to the other. There's those ones that are in between as well that are gonna push as far as they can absolutely push and
I
possibly
see.
push somebody over. You know what I mean?
I see.
And that's one extreme to the other. You know,
So,
I mean.
Are we good? Are you
Yeah,
done?
we're
Okay.
done.
All right. Of course.
Sorry about that. I forgot I had that there.
You can keep it in there. Just you got to understand, we're going to just address as a potential threat. It doesn't make it illegal.
No,
we just
yeah.
take it out of the situation.
Yep.
And give it back to you just like I did. Yep. Good.
Mr. Bowman Thomas faced charges of second-degree menacing and disorderly conduct, later being released on an appearance ticket. The final resolution of these charges remains undisclosed, and it is uncertain if the witness pursued any legal action. In January 2023, Chief Alves was terminated from his position at the Almira Police Department due to his conduct in a separate incident on December 9, 2022, involving an arrest where he threatened a suspect with a firearm. City Manager Mike Collins cited unprofessionalism and insubordination as reasons for termination, unrelated to the incident discussed here. Both Chief Alves and the assisting officer received a CI for maintaining an aggressive demeanor, making threats without probable cause, and misunderstanding when officers can demand to see a driver's license under New York law. Despite not illegally seizing the witness's cell phone and showing some respect for Fourth Amendment protections, the encounter was deemed unprofessional, likely infringing on the witness's Fourth Amendment rights. The witness received a B for maintaining a mostly firm but respectful demeanor. While occasionally being physically and verbally assertive, she consistently defended her constitutional rights. Although not legally obligated, she cooperated with the police, likely motivated by the threat of arrest. The witness's decision to record the altercation for protection rather than to gather evidence against Mr. Bowman Thomas highlighted the significance of officer demeanor in securing consent and cooperation. In summary, the encounter showcased the importance of respectful police-citizen interactions, emphasizing the need for officers to be aware of citizens' rights and employ less abrasive approaches when seeking cooperation.